11 News Alert. A man suspected of killing his wife is out of jail tonight after his bond was posted. That's according to Barry Morphew's attorney. This comes after a hearing earlier this month that altered the terms of his bond. 11 News reporter Cameron Dean is joining us now from the 11 Alert desk. And Cameron, Morphew's bond was $3 million.
Lindsay, his attorney tells us his supporters use a bondsman to post his bond. And you may remember in his court hearing earlier this month, the judge altered his bond from cash only to adding surety and property in his bond, meaning he could use a bondsman or equity from real estate. Also in this bond agreement, he is not allowed to leave the state. Now, court officials tell us he cannot possess weapons, will need to have an ankle monitor, cannot consume controlled substances, can only drive cars registered to him, and he must also relinquish his passport. Morphew will also be on house arrest. Barry Morphew's wife, Suzanne, was reported missing on Mother's Day in 2020. Morphew was previously charged with the murder of Suzanne before her body was found. Those charges were dismissed without prejudice. In 2023, Suzanne's remains were found in a shallow grave. In June, Morphew was arrested again and charged with first-degree murder. We reached out to the 12th Judicial District to ask how much he actually had to post to get out of jail custody. We'll let you know when we hear back. Morphew is expected back in court in early November. Back to you.
What up, Dope Biz Nation? It's your boy Tay Biz. Yes, you heard it correctly. This is a Barry Morphew case update. Yes, he has been released and posted bond, posted bail on a $3 million, which was once a cash only, now surety bond. And so just to give details on the surety, most of the time when you do a cash surety bond, where you have property bond as well, what you can do is, like the gentleman said in the news, you can utilize some of your real estate as collateral and things of that nature that equal out the amount of the bond. However, there is a 10% pay that you do have to give in cash in order for the bond to be honored or to be received. And so that is what he was able to do. Is a $300,000 cash minimum, 10% minimum. Okay, so it's $300,000, and then the rest of his estate and properties and things of that nature can be used for collateral. Remember, the last time we were here on the TBS TV channel, we did do a live on the Barry Morphew case. If you want to go ahead and hit the link in the description, you will see the full live that we did. Also, I do have a Barry Morphew folder that I'm going to also put in this description as well. It has the affidavit, it has the reindictment statements and all of those things. It has the details of the BAM chemicals that were found in Suzanne Morphew's body after it was moved, according to the reindictment, allegedly moved more than twice, okay, where her body was in one place and then it ended up being somewhere else, which is where they found it. And they found it, the bone marrow had a case of BAM, and BAM, the BAM chemical is a deer tranquilizer, or animal tranquilizer chemical that allows, a slow, painful death, I believe, of animals. He was a deer hunter, and so he was the only one who had the exclusive prescription in Colorado at the time in that area of those chemicals that were found in her body. Also, the prescription started in Indiana. Remember, Suzanne Morphew and Barry Morphew lived in Indiana for a nice period of time before they moved to Colorado. And so when he was in Arizona, he got extradited back to Colorado, where he was reindicted and also charged with murder of the first degree. And so now we see that he is out on bond. Okay. Barry Morphew is accused of first-degree murder of his wife, who went missing on Mother's Day of 2020. All right. And he was able to get a surety $3 million bond. As per the judge's orders, he was fitted with a GPS ankle monitor, and his attorney, David Beller, confirmed late Thursday that the night that the funds of the bond were paid by friends and supporters. All right. So he was able to get help. All right. And it could be friends that were able to access some of his money. Who knows? I don't know. Because remember, Suzanne Morphew had her own set of real estate and things of that nature that he took over after her being missing for so long. And so he was able to take over all of that estate. And so one of the properties we saw in Indiana was actually on Zillow. And if you go to the live that we did, you will see that one of our people in the chat actually pulled up the address to the house where now he has all reign over it. He has actual power of attorney over it because his wife was at the time missing. Now we know that she was actually murdered, and now this trial is going to take place. Remember, he was indicted before, but it was dismissed because of prosecutorial misconduct. Now they have the first degree murder charge again, single count, and so this is the tail of the tape when it comes to what this process was before finding the body. Now that we have found the body, it has changed everything when it comes to details and things of that nature. All right. It says here Morphew was released at around noon on Friday. Clerical errors made in the bond paperwork Thursday postponed his release, according to Alamosa County Sheriff Lieutenant William Squires. He said that during the 3 months that Morphew was in the Alamosa County Detention Center, Morphew was a superb inmate who kept to himself and had respect for the jail staff. The bail bondsman, Richard Jordan of Denver's A1 bail bonds, could not be reached for comment on how much cash Morphew had to post in order to be released from jail. Squires said that Jordan's registered license had expired, among other snafus in the paperwork, which had to be corrected before Morphew could be legally let go. Earlier this month, District Court Judge Amanda Hopkins denied requests for Morphew's bond to be reduced to $500,000, though she did change the requirement from a cash bond to a $3 million surety bond, which meant he could await trial at home if a bail bond company was willing to guarantee the money or someone is willing to put that value of property on the line. What I want to do right now is take a look at this video of the hearing, and I want you to see both sides. I want you to see the prosecution, and I also want you to see what the defense says in this bond hearing, and then you can go ahead and make your judgment from there. Here we go.
Thank you, Judge. Before I continue with my argument, for purposes of the Victims' Rights Act, Mr. Morphew's daughters have expressed an objection or a support of the defendant's motion to reduce bond. Meanwhile, Suzanne Morphew's sister, who's also on the line here today, as well as her brother, who submitted a victim impact statement, both strongly object to any modification of the defendant's bond at this time. Judge, defense counsel is asking for a reduction of bond specifically for the reasons that the court considered. When the court had the indictment in front of them and reviewed the information that we presented with respect to our bond argument, the court considered, for example, his previous performance on bond, the previous amount and conditions of the bond, took into consideration all of those factors that defense counsel has now asked the court to consider here. But I think the most important thing that the court considered was the court had the actual indictment in front of her and read that this case is a very different case than the one that was filed in 2021. Obviously the facts of this case will be litigated in trial. Defense counsel is asking the court to consider that the evidence presented in the indictment is just slightly different than the 2021 case. Nothing could be further from the judge. In this case, the remains of Suzanne Morphew were found. The remains of Suzanne Morphew after an autopsy contained a chemical compound that Mr. Morphew had almost exclusive access to, tying him directly to the remains of his wife. The case in 2021 was arguably entirely circumstantial with no body. This case is very different. I'm hoping that the court has been able to at least review some of the transcripts of the case presentation in front of the grand jury. Obviously, the court has the indictment. The transcripts will also describe in more detail and more depth the weight of the evidence against Mr. Morphew as he sits here today. So I think I differ with defense counsel in his assessment of the case that's in front of the court. It is very different than the one in 2021. Judge, the court has also considered specifically the behavior of Mr. Morphew in 2021 with respect to this bond. I know that the defense did not have the benefit of being here during my bond argument, but specifically the court asked me, was there any bond violations in 2021? What were the terms and conditions of his bond in 2021? And the court had all of that information in front of her when you determined that this was a different case and so a different bond should be set. I differ with defense counsel in his argument where defense counsel submits that a bond is too high if someone can't post it. Obviously, our jails that are full with people that can't post bond would argue in a different direction on that one. But the reality is the bond that Mr. Morphew the bond that the court has set is consistent with other bonds that are currently set against homicide defendants in the 12th Judicial District. Judge, the court specifically asked defense counsel whether or not the defendant has been using any other name. And obviously we can talk about the reasons why the defendant might have been doing that. But it's not just his middle name that he's using. He's using a last name that doesn't have any relationship or connection to his given name at birth. He's using the name Lee Moore, which is not related to anything that the defense has presented. Specifically, he's using it to conduct business in Arizona, and that's the concern that people have specifically. In addition, Judge, the court asked whether or not he's been in another state for a substantial period of time. Well, I don't have any facts to dispute what defense counsel represented. I would note that the defendant has been traveling frequently with 2 vehicles, interchanging license plates on those vehicles. In addition, we also have information and communication to suggest that the defendant has actively attempted to move around large amounts of money to different accounts. He has put properties that he owns in family members' names. He has also traveled well. He is absolutely entitled to do so. He does have the means to travel out of the country. And it's those things that give us a lot of concern about not only the fact that this is a different case, but the fact that this is a different judicial district. This is a different district attorney's office. This is an entirely different landscape. And I can imagine that the court would agree with me when I say that the defendant is under very different peril than he was in 2021. And for that reason, we have been monitoring his communications as well as his movements in terms of financial information. And it looks as though he is doing a lot of activity in that regard. Judge, he does have substantial means, but we don't have any information that he's actually been working for the last 6 months. He's been living in Arizona, but our information, at least preliminarily, is that he has not actually had a job. He does landscaping work, but we have not been able to find any kind of incorporated business or any business name that he's operating under. So we have great concerns about what he actually has been doing in the last 6 months, where his money is going, and why he is now actively trying to shift around finances. All of those things give us great concern, Judge. I agree with defense counsel. The defendant sits here innocent until proven guilty, and I fully support that concept of our criminal justice system. But the court has to consider whether or not the defendant is a flight risk. And in these circumstances, in these very unique circumstances, a bond of $3 million cash only, consistent with other defendants in this jurisdiction, is appropriate. And the defense has not presented the court with any other material information that would support a modification of that bond at this time. And if I can just have one more question. Sure.
I do have a question for you.
Sure.
The license plate that you've brought up that was switched between vehicles, was that license plate that was registered to Mr. Morphew or to
It is,
someone else?
It is.
In his own name?
It is. It is an Indiana plate, and he's been living in Arizona for a long period of time.
Okay, but it's in the name of Barrymore.
That's correct.
Thank you.
As far as we can tell, I don't think we have any information that he's registered any vehicles in Arizona. He has not.
Thank you. Go.
Thank you, Your Honor. So I want to be a little bit careful recognizing who our audience is, and it of course is the court. Your Honor, the transferring of large amounts of money, I believe, is a reference to a trailer that Mr. Morphew is residing in Arizona, and a home that Mr. and Mrs. Morphew had purchased in Indiana for roughly $200,000 and transferred it to his mother because his mother is residing there. Mr. Morphew's significant financial substantial needs are something, of course, that has not evidenced itself so far in the roughly 9 terabytes of discovery that has been presided to the defense. And ultimately, the court should know that Mr. Morphew was in fact living in a trailer park in Arizona, and was driving, and his daughters were driving the same vehicles since those that had been seized and returned to them by law enforcement. There is not a substantial amount of money. I am hesitant and going to be very careful in talking about the one piece of factual evidence that the district attorney raises in addressing that. Insofar as the indictment, Your Honor, as the court knows, that is a cherry-picked piece of narrative that has been created exclusively by the district attorney, using agents by the district attorney, and by going through the grand jury, there is no opportunity for the defense to be able to publicly rebut anything that has been said. That is but mere allegations, and arguably and laughably, oftentimes wrong and incorrect. The BAM that the district attorney mentions that Mr. Morphew had access to, I want to be clear on, was prescribed to him in the state of Indiana in 2018. Mr. Morphew has not had access to BAM since 2018, and the indictment says that nobody in the immediate region, meaning the 12th Judicial District, who was not otherwise lawfully prescribed BAM, had access to BAM, leaving out the fact that Mr. Morphew himself has not had access or prescription to BAM since 2018, and ultimately, law enforcement did not find any BAM in Mr. Morphew's residence, in his garage, or in his gun safe. And so this narrative that the people put in their indictment that Mr. Morphew has ties to and access to BAM and is completely silent to the fact that that was an out-of-state prescription legally prescribed to him for a deer farm that he had not owned in years, in my opinion, is something that is not particularly relevant to this court's analysis, only insofar as rebutting the fact that the people asked the court to take into consideration a one-sided indictment with a soundbite of BAM and leaves out the context in the initial and the additional narrative. And so the bottom line is, in this case, my premise and my argument remains, which is that Ms. Bryelson and I have the burden of representing an innocent person next to us. And we believe that the facts are going to be flushed out when given the opportunity for that to be a two-sided narrative and not a one-sided narrative that we then ask the court to simply believe and take as completely and totally truthful and accurate. Ultimately here, the purpose of bond is to ensure Mr. Morphew's compliance with court order. And we are, in fact, asking the court to only consider both what has been argued today as well as the statutory factors. Thank you.
All right. As you can see, the defense attorney is saying that Barry Morphew was prescribed BAM in 2018 and hadn't had any with him, right? Allegedly. However, we do know that when they searched the house of Barry Morphew, they found needles in the dryer of the clothing of Suzanne Morphew, I believe, or his clothing, one of the two. But they did find needles that had the same look of the BAM chemicals that would come in a certain case. So even though he's saying that, at the end of the day, it doesn't really matter, brother. It doesn't really matter because, again, he is the only one in that area that had the BAM prescription legally in that state, in that area, exclusively him. All right. So that right there is a huge red flag. Also, what is another motivating factor? The relationship that they had, the marriage that was being dismantled. They both were cheating on each other. They both had someone else that they were kicking it with, talking to, texting, or whatever. Both of those individuals have been removed as a person of interest or anything of that nature. But Suzanne Morphew, remember in the indictment that we read, said, "Hey, I know that you're talking to other people, and I don't even care anymore." All right. So very, very interesting that the defense is trying to paint it in a way that it could not possibly be him at all, when really he was still the only person that had this prescription. Let's go back to this real quick. Morphew was liquidating all of his assets in order to pay his legal bills, according to Beller, and will be preparing for trial while confined to a Colorado residence. Under stipulations from the court, he will only be allowed outside for legal and medical appointments. An Alamosa County Sheriff's deputy confirmed Wednesday night that Morphew was still at the Alamosa County Detention Center as he prepares for his release. We all know that he has actually been officially released now. And actually, according to the Alamosa Sheriff Department, they actually posted on their Facebook page the release of Barry Morphew. The fact that Morphew made bail was first reported by the Alamosa Citizen. Morphew has been in custody since June after he was indicted by a 12th Judicial District grand jury. He was arrested in connection with the murder of his wife, Suzanne Morphew, June 20th, in Gilbert, Arizona, during a traffic stop by the Arizona Department of Public Safety. For months, he had been living in Arizona under the name Lee Moore. All right. Now, he was calling himself Bruce. Then he was Lee Moore, Bruce Lee Roy. Suzanne Morphew, 49, disappeared from the couple's Chaffee County home in May 2020 on Mother's Day, sparking a massive search. Despite never finding a body, Morphew, 56, was arrested on suspicion of murder in 2021, but the case was dropped after alleged prosecutorial misconduct. Prosecutors allege he and Suzanne Morphew were in a combative relationship and that his phone was turned off for a long period the day she vanished. Remember the phone situation. It's in the indictment. The phone situation is very, very important. Like all of a sudden, he was contacting, and the children were calling, all this kind of stuff. Then when she was missing, nothing. All right. Absolutely nothing. In subsequent interviews, he and his daughters professed his innocence. But in 2023, human remains were found in rural Saguache County in the San Luis Valley that were identified as those of Suzanne Morphew. According to the grand jury indictment, the bones tested positive for a wildlife tranquilizer for which Morphew had access, and that he is the only person in Colorado with access to it. The next hearing in the case is set for November the 3rd. As for when the case could go to trial, attorneys said it would be next summer at the earliest. So we're looking at November the 3rd. It will be the next time that we actually get a chance to see him in court. And we're going to see exactly what happens. When is the trial date? And things of that nature. We'll keep you posted on that. But what do you all think about this bond being modified the way it had? I mean, it was a cash only bond, $3 million cash only bond. Then all of a sudden it was a bond for a cash surety, but with modifications. And so I think his behavior inside of the jail, not having any priors, was something that was possible, that could have been a factor in the fact that he got the modification that he got. But no one really thought, I'm assuming no one really thought that he was going to be able to post his bond. But we all know that Barry Morphew had his own company, construction and all that kind of stuff. Even though he was not licensed, remember, he was supposed to go to a project somewhere and he made a detour. All right. He did all that kind of stuff. So he had his own company and things like that. And so he had money, he had property, he had real estate, he had investments and things of that nature. He was able to use and liquidate his assets in order to pay for the bond. So I'm curious to know what you think about this. Please leave your comments below, like, share, subscribe to the channel. Also want to just say a shout out to all the new subscribers that have subscribed to the channel, that have reached out to me through the comments. I really appreciate you so much. This is your boy Tay Biz, and I'm out. Peace.